Figure out the mute button. I hate it.
We are recording.
All right, good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Albert and Judge Alexander on the matter of Allen versus Commissioner of Correction. AC docket number is 42781. We're conducting this argument over the Teams platform, which means everyone is appearing by video conference. In addition, the argument is being streamed live over the branch's YouTube channel and will be posted on the branch's website. I would remind counsel that to the extent there's any protected information in this case, they should be careful not to disclose that protected information during the course of the argument. I'm going to ask everyone to introduce themselves so we can make sure we can all hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
Good morning, I'm Judge Albert.
Good morning, Judge Alexander.
J. Patton Brown for the appellant, Your Honors.
Margaret Radionovas for the Respondent Commissioner of Correction.
All right, I can hear and see everyone. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. If you lose the connection for the conference for whatever reason, please go out, click back on and rejoin. We will suspend the argument until we know that everyone is present. Although this is a virtual argument, I would ask everyone to conduct themselves as if they were standing in the physical courtroom at 75 Elm Street in Hartford and follow the same protocol that you would if you were in the physical courtroom. I am going to ask, though, that when we're during the argument, that if you're not speaking, that you mute your microphone to avoid any unnecessary background noises and avoid any talking over each other. The judges will similarly mute our microphones. If we have questions, we're going to raise our hands and ask counsel to recognize us. If you do not recognize us, we'll just jump in like if we were in the physical courtroom. But again, we're trying to avoid talking over each other. Each side will have 20 minutes to argue. The appellant can reserve time for rebuttal. I will keep the time because we don't have our lighting system. I have signs to hold up at 2 minutes, at 1 minute, and when your time is up. So with that, I think we're ready to go. Attorney Brown, are you ready to proceed?
I am, Judge.
Okay. If you, your voice sounds a little soft, so if you could just turn your microphone up and steady your camera. It's kind of moving around all over the place.
Sorry. Let me, I don't have a podium. Let me put it over here on a little stand I have. Can you hear me better now?
That's better. Thank you.
Okay. I would reserve 5 minutes for rebuttal in case anyone has any questions or something comes up.
Okay. You may proceed.
Thank you, Judge. This is, again, another one of those cases where it's the second, actual habeas trial appeal and the third habeas that Mr. Allen filed. This is not a very complex factual scenario. It seems like a pretty straightforward issue, at least factually, as far as I'm concerned. I will certainly agree, as Your Honors probably can tell from the pleadings, that beginning with the amended petition on the third habeas and the questioning at trial, that it could have been a little clearer as to what the issue was. But I would submit respectfully that it is, pretty clear that the issue in this case is whether or not now Judge Harmon was ineffective for not pursuing a defense that involved proving that Mr. Allen was drug dependent in the hope that it would spill over into the conspiracy charge. By that I mean, if Mr. Allen is drug dependent, and since they did find him not guilty of drug sale, that could have kind of sealed the deal, and they may have found him not guilty of a conspiracy to sell drugs. Because they had some reasonable doubt. I mean, I guess we can never tell unless we talk to them, which is on rare occasions what a jury actually thought. But they clearly had a reasonable doubt as to whether the testimony about the actual drug transaction was true because they acquitted him of those charges. I would disagree with the state's contention, and it seemed to be Attorney Harmon's contention on questioning when he testified at the first habeas trial, that the fact that he was drug dependent is not really relevant. Well, it is true that it is not a defense to the conspiracy charge, but to say that it's not relevant to it, I don't think it's true. I also don't think it's really an inconsistent defense. It can be an inconsistent defense, but it can also be a consistent defense, because I say that even if he had been only charged with the conspiracy charge and not the sale charge, because it can be a defense. In other words, hey, I'm not engaged in a conspiracy to sell drugs. I'm just a drug user, so I happen to have an association with the drug dealer that they're accusing me of conspiring with, or I may actually be there to purchase. I'm not there involved in the conspiracy to sell. And while I think the one thing that could have been explored more, because Attorney Harmon seemed to indicate, and I guess it's not really, I can't say that this is what he meant, but when he testified at the first trial that it wasn't pertinent to the conspiracy charge, it seemed to me like that could mean that he didn't think it could be brought up in any way. It may have just been a statement of law in response to a question, but that was not explored. And I do have to concede factually, however, that Attorney Russell, who was the trial lawyer at the habeas court, did testify to the effect that that Attorney Harmon had told him that this defense that was presented was Mr. Allen's idea. I suspect the state's going to bring that up, and I really have nothing to refute that with, because that's what was testified to, other than there should have been more of a cross directed towards that as to exactly what Attorney Russell meant. And I also have to agree that Attorney Bowers, who was the trial lawyer in this case, did. I don't know if I can agree with their characterization that he seemed to throw in the questioning and argument about he never used the word spillover effect, but the spillover effect towards the conspiracy charge. I don't know whether he seemed to do it at the last minute. I don't know if I would characterize it that way, but it was done at the end, and seemingly with a couple of questions. Factually, that's correct. I just don't ascribe the same significance to it as they do. Again, this was a quick trial with a quick issue. And if the court has any other questions, I will answer them. Otherwise, I will stand on my papers.
I had a question for you, Attorney
Yes.
Brown. Do you agree that if a special defense of drug dependency had been raised, that would have exposed the defendant to the risk of conviction on the lesser included offenses of the drug possession and drug sale charge by a drug dependent person?
That's certainly possible, Judge, but I think it depends on how it was framed, and we don't really know the answer to that question, because we don't know if it would have been pursued as a straight defense that, hey, I was there with drugs at that time, and that's you know what I mean?
Let's assume it was pursued as, I didn't do it, but in any event, I was drug dependent. Wouldn't there be a risk that the jury could say, well, these inconsistent defenses cause us to question his credibility completely, and therefore we're going to convict him at least of being involved in the sales, even if we find that he was drug dependent?
Well, of course, that's possible, Judge.
Right, and isn't that something isn't that a reasonable risk for a trial attorney to take into account in formulating his strategy for trial?
If that's why he did it, yes.
Okay. All right. Any other questions? All right. There are no other questions, so you'll have 8 minutes and 45 seconds if you need it for rebuttal.
Thank you, Judge.
Okay. So, Attorney Radnovich, you ready to proceed? You're on mute.
Thank you. Good morning. May it please the court. I'm Margaret Radionovas. Can you hear me?
Yes.
Okay. I'm Margaret Radionovas. I represent the respondent appellee, the Commissioner of Correction. Your Honors, I think that today and in his reply brief, the petitioner has made more clear that his claim is that the failure to raise drug dependency refers to the charge of sale of narcotics by a non-drug dependent person, as opposed to any of the other charges. I think what this means is that the petitioner cannot prove prejudice because he was acquitted of that charge as well as the other narcotics charges. And beyond that, I don't think I have much more to say other than what's in my brief. If the court has any questions, I'll be glad to answer them. Otherwise, based on my brief, I would ask that the court dismiss the appeal.
All right, I see no questions. So Attorney Brown, I was actually wrong on the time. You have 8 minutes 45 plus 5 minutes. So you have up to about 13 and a half minutes if you need it for your rebuttal.
Your Honor, I won't need that. I will just simply state that our position is I mean, he was acquitted of the sale, so that's obviously not what I'm trying to argue. What I'm trying to argue is that the spillover effect would have benefited him on the conspiracy charge. That's all I have to say.
All right, I see no further questions. I want to thank you both for participating in the virtual courtroom today. We look forward to seeing you both in our physical courtroom sometime in the very near future. We will take the matter under advisement and we will stand in recess until 10:30 this morning. Have a good day.
Thank you, Judge.
Thank you, Your Honors.